Hello everyone. Let's proceed on to the remaining chapter, NCRT, Indian Constitution, and the name of chapter is Rights in the Indian Constitution. Now let's talk about the widest and the most dynamic article in the Indian Constitution, that is Article 21, that forms an inseparable part of not only fundamental rights but also a dignified life for all Indian citizens. So Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law, and which means that your right to life, it won't be taken away, it won't be stifled with, it won't be violated by any legal or constitutional authority, and also by any individual. And but as I already told you, no right is absolute. So the reasonable restriction or the exception here is that your right to life, it is subject to law. It is subject to the procedure established by law, by which it means that your right to life, it can be taken away by procedure established by law, or in short by law. Which means if you commit a crime, you cannot cite your right to life. If you murder someone, if you uh, commit a heinous crime or cause some major grievances to someone, in short, if you commit a crime, whether it is of civil nature or criminal nature, both of which will be dealt by law according to the procedure established by law, which means the procedures that are written in our law, in our law book, which not only constitute constitution, but also other ordinary laws, other judicial verdicts, and the Indian Penal Code, along with Code of Criminal Procedure, CRPC. So, both the section, the Indian Penal Code, IPC and CRPC, both are the tools or the legal precedents that were used by the police authority and judicial authority um, to act against or to decide against any act, whether it comes under a crime or it is just a general act. So both of these, they in IPC and CRPC, they form part of law, and these are the procedures that can take away your right to life. Other than that, your right to life, it is sanctified. And when I started the chapter, I said this is the most widest and dynamic right to life, and it isn't a big task to assume why that is so. At first, life itself is dynamic. So with every passing moment, there comes a plethora of challenges. When life itself is dynamic, so will be the rules and laws that govern them. A dynamic life requires dynamic law. This will how a society can sustain itself even with some jerks. Since uh, the problem with present legal jurisprudence is that law is something that is written, and everything will be written only after much discussion, especially in democracy, much discussion, deliberation, negotiation, or much talks. And much talks, it means it will take time. So everything that is written in a law book, it will be time delayed. But time does not wait for anyone. It passes unstoppingly. So in that case, whatever we write in constitution, whatever we write in the law book, it must be in consonance with, it must be in synchronization with time. So in such a case, the law that is written, it should be that flexible, it should be that agile, it should be uh, plastic in itself, plastic, or you can say flexible in itself, that once written, it can at least cater a certain time pocket. So right to life is an example of resilience, flexibility, plasticity, and it has catered to our demand. And other than that, when I talk about Keshwanand Bharti case, Keshwanand Bharti case was a milestone in Indian constitution. So in that case, the Supreme Court or judiciary, it came up with a doctrine of reasonable restriction. Reasonable restriction that is also known as the basic structure, reasonable restriction over all the authoritative acts, and the doctrine that came out of that verdict is known as basic structure, which means since the constitution has granted parliament the authority to change law, the power to change a law, and both article 13 and article 368 both are testamount to that power, and parliament enjoy sovereignty, supremacy in amending the constitution or changing the constitution. But since parliament has the supreme authority to change the constitution, it is it may be the case that parliament, if it becomes majoritarian, or authoritarian, both of which means that the power, it is not distributed among a lot of people, but is concentrated by a few, concentrated by a few who represent the majority. That is majoritarianism. And authoritarianism means that the authority is concentrated in a single or a group of authority, a group of people. So in such case, misuse of both these provisions is possible, since if the power that is concentrated in a group and that group wants to change the cultural landscape of India, which became evident both in case of Indira Gandhi and Narendra Modi, and especially the changing of cultural landscape, it is still visible in the present government, uh, because they have a Hindu nationalist agenda, and that agenda is against the democratic practices or the inclusive culture by which the constitution was made, by which the freedom struggle was fought. So this inclusiveness of bringing all shades of opinion, bringing all shades of views, perspectives, opinions, culture, cultures, religion, languages. So the the constitution, when being drafted during the earliest time of independence, it had an inclusive character. It was because of diverse geography of India, and diverse geography is uh, an insignia of diverse culture. So to accommodate diverse culture, The law book, it must be inclusive. But the present government or the present group of people, group that are handling the national affairs, they are religious. Their outlook is religious, not political or not religiously neutral. That should be the case. But since they are advocating an agenda that is culturally hegemonic, that they are hell-bent on making India a Hindu country, which it is not. Yes, Hindus are majority. Hindus are around 80% of the population, but the 20% of the population itself, it is diverse. And the 80% Hindus, they are not homogeneous group. There are many caste groups, there are many sects, there are many categories, general, OBC, SC, and other than that, there are many cultures. So as I have given this example that a Brahmin of UP and a Brahmin of West Bengal, they have a lot of differences. A Brahmin of UP is never going to touch non-vegetarian food or meat-based diet. But a Brahmin of West Bengal, he has no way to go. His staple is fish and rice because that is what his geography permits. His religion or um, his sacred thread may not allow it, but his culture or the present locality in which he lives, only fish and rice is the diet that can be called a staple that is available in plenty or that can be available all the time. He is not going to take a lot of effort. Not only he, a whole group of West Bengali Brahmins, they are not going to take pains and efforts to arrange a vegetarian diet so that their sacred thread or um, their piety with the vegetarian Brahmin diet can be assured. This is not possible and this is not viable. So my point is, even the 80% Hindus, they are not homogeneous. So to stifle with such cultural landscape is to cause a lot of frictions, and that becomes possible when the parliament has given a lot of authority, and and the majority of people who are elected to such parliament, they hold the same view to changing the cultural landscape, in which the constitution itself comes under threat. So to protect the constitution against authoritarian attacks, the judiciary came up with the doctrine of basic structure, in which basic structure of a constitution cannot be stipulated, it cannot be changed, and if changed, the constitution would lose its meaning. It will be a whole new constitution. So this protection, this judicial intervention helped a lot in protecting the constitution and the cultural landscape of India. And other than that, the same judicial interventions, time and along, they have come with a lot of different interpretations, a lot of newer and dynamic interpretations, much of which concern with the right to life itself. So right to life, it has broadened itself and it is still broadening itself to include whatnot. So every section of people, they have been included in it. Their demands have been included, such as you might not have heard about um, a judicial verdict in 2017 and 18 when judiciary it banned cracking cracking of firecrackers. It banned any alcohol and tobacco-based product in the vicinity of schools and hospitals. It has granted the right to life to LGBTQ community. It has ensured the entry of women in temples. It has also ensured the right to life of the tribal people who have been evicted because of development projects. So all these interventions, they have broadened the definition, or the broadened the listing of rights that can be a part of right to life under Article 21. Now coming back to NCRT. So now next let's talk about right to freedom. Liberty means freedom of thought, expression, and actions. Yes. So right to freedom, it is inseparable from right to equality. So you can be free only if you are equal, and you can be equal only if you are free. So this is a reverse and obverse situation, vice versa kind of. If you are not equal, you cannot be free, because if you are not equal, you will not be given equal rights. So at the time, your freedom itself, it will come under scanner. And but if you are free, excuse me, if you are not free but equal, so that's a mockery of justice everywhere. How can that be the case that you are equal but not free? So either you are not free at all, or either you are not equal at all. So both equality and freedom, they go hand in hand. And the line here, it expresses that feeling. Liberty means freedom of thought, expression, and action. Yes, so it is only when you have freedom of expressing yourself that you can be called equal. And you can be called equal only when you have freedom of other things. And the last, freedom are defined in such a manner that every person will enjoy her freedom without threatening freedom of others and without endangering the law and order situation. So the right to freedom, it is a two-parter. At first, you you will enjoy your freedom only when you care about the freedom of others, and then you also care about the law and order situation. So you are free only when others are free, and then the law itself, it is not stifled by your actions. Then comes right to life and liberty. Notes, I have already explained this in length. That means no one can be arrested without being told the grounds for such an arrest. And if arrested, the person has the right to defend himself by lawyer. And it is also mandatory for the police to present that person to nearest magistrate within 24 hours. And this is to ensure that the police or any such authority do not misuse their right to arrest. So if a person is arrested, he has both the rights. First, he can defend himself with the lawyer, and second, he will need to be present before a nearest magistrate within 24 hours, so that his arrest, it is not arbitrary and it is not on frivolous grounds. Now let's talk about the Supreme Court intervention in right to life, that it has also included the right to live with human dignity, to free from exploitation, right to shelter, right to livelihood. So in all means, the the judicial intervention or the judicial interpretation of right to life, it has broadened the definition of Article 21 in such a way that it is called the most dynamic right most dynamic fundamental right of the Constitution. Now let's talk about preventive detention. Ordinarily situation, a person would be arrested after he or she has reportedly committed some offense. Yes, this is the usual case, and this is what we believe in our mind when we talk about arrest, that a person can be arrested only if an offense or a crime has been committed by or he has been committed, accused of committing such a crime. Yes, this is the usual scenario that comes into our mind, but there is another situation. First, person should be arrested because of either accusation or commitment, both of which either he is accused of committing a crime or either he has been seen committing a crime. In both cases, the person can be arrested, and this is a clear scenario that we keep saying and we have in our mind when it comes to arrest. But the another dimension is preventive detention. Detention. So it means to detain someone. Detain means to arrest. To arrest someone to prevent a crime. So if it is believed by the police authority based on evidence that a certain person is going to commit a crime, and those crimes need to be major crimes such as some terrorist activity or some other crime that are heinous in nature and may jeopardize the freedom and lives of people, or may threaten life and property in general. So that person can be arrested preventively, or that person can be arrested in advance even before he has committed, or he has uh, set off for committing a crime. So now this thing, first, it is really a good prevention measure, especially if if the security of India or security of society as a whole comes under threat, especially since if terrorists, based on evidence that has been gathered by police authority, so a terrorist has arrived in your locality or in any part of this country, and it has come under notice that the terrorist is planning a major attack. In that case, the police authority will not wait for that terrorist to commit the crime or explode the bomb or cause uh, major loss. The viable or the plausible action should be to arrest that person if the evidences are against him. So this preventive measure, it is based on evidences only. But this provision can be misused. It is prone to misuse since the arrest, it can be arbitrary. Since the provisions of such preventive detention, these are so severe that the accused that has been detained, he has no right to no right of a lawyer, and he can be detained for a long time, 3 months and 6 months, and his judicial access, that is also limited. So the potential of misuse of this provision, it has been severe, and we have recently seen the misuse of this provision by political authorities, that many prominent persons, many uh, many journalists and many activists, they have been accused of frivolous crimes and have been detained under the provisions of preventive detention, so that their movement, their access, and their activity, it can be hampered, it can be put, it can be stopped. So preventive detention is a good measure when it comes to security of India, but it is also likely to be misused. Yes, sometimes a person can be arrested simply out of an apprehension that he is likely to engage in an unlawful activity. Yes, this is known as preventive detention. It means that if the government feels that a person can be threat to law and order or to peace or security of nation, it can detain or arrest that person. This detention can be extended only for 3 months. Yes, and after 3 months, such case is brought before an advisory board for review. And after 3 months, the same board, it can also extend the detention for 6 months. On the face of it, preventive detention looks like an effective tool to deal with antisocial elements, terrorists, or subversives, but it has often been misused by government. Yes, so there need to be safeguards against it. Next, talk about other freedoms. The freedom or the rights that are not absolute, and all of these freedom, these rights, are subjected to restriction imposed by the government. Examples are given here, such as right to freedom of speech and expression is subject to restriction, and the restriction are public order, peace, and morality, which means if you have freedom of speech, you you cannot incite violence, you cannot um, indulge in any activity that is against public morality, such as you cannot dance nakedly before a multitude of people, nor you can um, nor you can use arms or indulge in some those those uh, activities that are against public morality, such as prostitution, such as selling alcohol before temple authorities, or to malign the dignity of women in public places. Other than that, the freedom to assemble, it is also need to be exercised peacefully and without harms. So if you have been given the right to assemble, to form associations, or to protest against any wrongdoing, you need to do it peacefully. You cannot use arms. And many times government may impose restriction in such certain area if those are violent prone, such as the curfew that is imposed on many pockets during riots, and a certain section of IPC 144, it has been imposed, it is being imposed so that assembly of 5 or more person can be stopped. And it has been seen that these powers are easily misused by administration. Now, uh, let's talk about right of accuse. A constitution ensures that person accused of various offenses would get sufficient protection. So why has an accused person been given these many rights? It is because law is blind and we do not know if a person has really committed a crime. Just on uh, just based on what people say or what media has projected, we cannot convict or hang a person. It this accusation, it need to be followed by a police, an administrative, and a judicial inquiry. Only after which the evidence, whether clear or circumstantial, that go clearly against the person, and the conviction of the crime is duly attested, that person is free of any charges. So before law, every person is innocent before being accused or before being guilty. So lines given here such as, we often tend to believe that anyone who is charged with some offense is guilty, but this is not the case. So no one is guilty unless the court has found the person guilty of an offense. And this this is a procedural activity, a judicial procedure that the court, the authority that has been charged with, the authority that has been bestowed with the role to judge whether a person is innocent or accused. So unless court has found that person guilty, that person is innocent. So in that scenario, person accused of any crime should get adequate opportunity to defend himself or herself. And then to ensure a fair trial, Constitution has provided three rights. First, no person would be punished for the same offense more than once. Yes, if a person has committed an offense, say theft, and if he has been found guilty and he has been sentenced to 3 months of jail, that same person cannot be subject to double punishment for the same offense. For sentencing that person for more than 3 months, or for sentencing that person again, he should have committed some crime. Otherwise, it will be total anarchy, and the whole judicial mechanism or judicial machinery would lose its meaning. Then no person shall declare any action illegal from a back date. And that another would be that everything that happens before a court of law, it should have a present date. It means if you have committed something now, and so you will be accused, you will be um, say you will be convicted of the crime that is a crime in the present time. Let me elaborate this. So let's talk about present time, December 2024. So on this date, a person A, he has indulged into some action. Say the action is to drive a terrorist around. Now A, who is a taxi driver, he does not know that the person he is driving is a terrorist, and nor does it concern him, since in a day he drives around a lot of people. And now that person, the terrorist, it after a few days he commits a crime. He indulges into antisocial activity, whatever that be, whether it is an explosion, a suicide bomb, or a terror planning, or plane hijacking, kidnapping, whatever it is. Now, in December 2024, taxi drivers are not charged, not convicted for driving people around, because it is not possible to check anyone's identity. And other than that, there are many forged identities, and taxi driver who are mere, hand to mouth living person. They don't have the whereabout, the technical know-how to check whether an identity is forged or not. So taxi driver, they are not to be blamed here. They are innocent here, and there is no law charge those taxi driver for driving people around. Now, if the same authority law it it comes up with a law a law to charge those taxi drivers of driving terrorists around, which they do not know who they are, and the authorities, government of India, it has come up with this new law, and it has enacted it via a backdate. So in December 2024, government comes up with a new law, and that new law it charges all the taxi drivers from January 2024. So it has enacted the law, and uh, it has started it with a backdate. So what will happen now? All those people, all those taxi drivers who have drove people around between January and December 2024 for 12 whole months, and even if it is assumed that each one of them they drive 50 people every day, and that multiplied by 20 days of driving, so now this is 600, 1200, 1,20,000. So now those people, all the taxi drivers, when such a crime or such a law is enacted with a backdate, each taxi driver, it it has been charged with driving a terrorist around, and that pool of people from which they can be accused or they can be charged with, it is now grown up to 120,000 people. So out of 120,000 people, anyone can be a terrorist. So if it is accused not just 100, even if one people who has appeared to be a terrorist by the authority, such taxi driver would be going to jail. And this is a grave scenario. And the same law, the same backdate in action, backdate in enacting of law can happen in every sphere. So if government find any protest against any activity to be unlawful, and it wants to misuse a provision, it can enact, or it can make the provision against that activity to be unlawful, and it can enact it via a backdate. So if students are protesting against any government action, such as um, a recent economic decision, a recent tax relaxation, say government has relaxed tax for a certain group of people. Now if students are protesting against it, so government can declare this protest. Government can say to protest against tax relaxation is an unlawful activity when seen in terms of national security. So all of these people, they are anti-national. All the students are, they are anti-national, and as such activity has been declared unlawful and anti-national, it has been enacted from a past date, say January 2024. Now all those people, all those students who have protested against government in all these 12 months, somewhere, somehow, they will be charged with it. So this is a provision that can be misused. Government cannot come up with a back date. And next, right for accused is no person shall be asked to give evidence against himself or herself. It means government or police authorities, they cannot torture a person to uh, to provide evidence against himself. And it has happened. We have seen in old movies that a person, if he is tortured more than he could handle, at one point of time he would become so helpless that he would be readily and voluntarily be giving himself to the police, or be giving in to the demands that has been asked by police, and the police will automatically ask him, tell him to accept the charges. And the constitution has provided all of us with this right, that you will not be asked, and you cannot be forced to provide evidence against himself or accept the charges that are made by police, by extortion or by torture. Then comes right against exploitation, Article 23, 24. So in which, um, first, begar, it has been abolished. So begar was a practice that prevalent in the ancient times, that has prevailed for a long time, in which people used to work for some people without any fees, without any charges. And it happened that at that time, this relationship, especially between Jamindar and poor people, Jamindar and poor people. So Jamindar, or you can say rich and poor people. So rich people, they were educated, they had the resources, and if any at any point of time, if poor people, he has borrowed from the rich people. So the uh, rich and the poor, the account will be settled by poor accepting the terms of condition, under which poor will work for the rich person until or till the charges or the payment, it has been paid in totality, a payment being made in totality. So such such were the terms of condition. But the rich people, they used to indulge in this tampering with the borrowed amount. They used to charge interest on interest. They would uh, make some adjustment, make some falsified account, so that the poor people, they could never be able to repay their borrowed amount. So uh, a borrowed amount of 500 rupees, it would be charged twice. Interest would be accrued on it, or the 500, it may be made 5,000. Somehow the poor people who were not educated, they used to give in to these demands, and the poor people, they would work free of cost, without their accounts being settled, or without their borrowed amount being repaid. And if a person, if he dies without repaying the amount, his children would work for the rich people or rich man, and the account would never be settled, and this will become an intergenerational activity. So constitution, it abolished this practice with the enactment of constitution. And then there was activity of buying and selling of human beings, and both of which has been prohibited and abolished under constitution. So forced labors was imposed by landlords, moneylenders, and wealthy persons in the past. Some form of bonded labor still continues, but it is a crime. And also constitution forbids employment of children below age of 14 years in dangerous job like factory and mines. So child labor has also been made illegal. Now comes right to freedom of religion. So according to Constitution, everyone enjoys the right to follow the religion of his or her choice. And this this freedom of religion has been incorporated because in the past happened that with the changing of ruler, the subject population, they were either persecuted or forced to convert the new religion. So right now this freedom has been granted that no one would be converted or forced to convert to the choice of the religion of ruler. Then comes freedom of faith and worship, that freedom of conscience is also there. Yes, it means a person may choose any religion or may not choose to follow any religion. So it is your choice. And freedom of religion also include freedom to profess, follow, and propagate any religion. If you are attached to any religion, you can practice and you can also propagate it. But there are certain limitations that it will be subjected to public order, morality, and health. Mm, First, you cannot proselytize. Proselytize, it means to induce person with any means to convert them to your religion. So this proselytization, it should not be it should not happen in the such inducing way in which poor and uneducated people, they are given the they, they're induced by giving such monetary benefits or showing some greed. And as a matters of uprooting many social evil, since freedom of religion is subject to morality and health. So practice such as sati, bigamy, human sacrifice, mutilation of female genitals, or child marriage, all has been abolished. Any such practice that has been a part of any religion, but it is also not consonant with present status of health and public morality, it has been abolished. Yes, and freedom of religion is also a matter of political controversy. At one hand, the people constitution has given the right to propagate one's religion so that the people can be persuaded to convert from one religion to another. Yes, but it is also be based on inducement or intimidation. So such forcible conversions have not been allowed by the constitution. Then comes equality of all religion. Since we are a mosaic of different religions, we are a mosaic of different cultures who are practicing different cultures based on their local conditions. So the constitution, in order to go provide equal treatment to all people, equal treatment to different religions, it has adopted a secular approach, which means government will not favor any particular religion. But as we have seen in the previous, this freedom of faith and worship, that government has taken steps banning sati, bigamy, or any such religious practice that is against public order, morality, and health. So government can intervene to make reforms. So, and we have talked about both the facets in when we talk about India being a secular country and the Indian version of secularism that has been adopted by Indian leaders. And we have also seen that under the right of equality, there is a guarantee that government will not discriminate on the basis of religion in giving employment. So both Article 14, 15, 16, in which Article 14 is right to equality, Article 15 is access to public resources irrespective of your religion, and Article 16 is opportunity to hold a public office irrespective of your religious affiliation. So all such rights have been given. then the institution run by state will not preach any religion or give religion education, nor will they favor person of any religion. So many such uh, rights have been given, but in order to hold the principle of secularism in letter and spirit, there have been reasonable restrictions that have been placed on these rights. Now comes the cultural and educational rights, Article 29 and 30. So, cultural diversity is the strength of India. India is not a monolithic society. We are not homogeneous people. We are heterogeneous people who are practicing different cultures, different religions, and different ways of life. And in such a case, the numbers itself, the numbers of different cultures, the people of different cultures, they are not distributed homogeneously or distributed evenly. So some people are in minorities, some people are in majority. And to protect that strength, to protect the diversity, Constitution has given the fundamental rights to minority to maintain and preserve their culture. And Constitution has given both cultural and linguistic minorities the right to have their common language to protect their culture, and such communities have a culture, language, script of their own and have the right to conserve and develop their own culture, their language. So when we talk about culture, we implicitly talk about language, because I have already time and again said this. Language is the expression of a particular culture. Yes, all minorities, religious or linguistic, can set up their own educational institution, and they can also preserve and develop their own culture. Then comes the right to constitutional remedies, Article 32. So, merely writing down these fundamental rights is not enough. There need to be a way through which this practice it can be defended or protected if violated. So, right to constitutional remedies is the way by which protection of violation of those fundamental rights it can be achieved. And Dr. Ambedkar it has considered right to constitutional remedies, the Article 32, as the heart and soul of the Constitution. It is because this right it gives citizens the right to approach High Court or Supreme Court. People can approach High Court under Supreme Court under 32 and High Court under Article 226. And both of them can approach only if their fundamental rights are violated. Other than any encroachment on their ordinary legal rights, they have to follow the same procedure by which first an FIR would be lodged at the nearest police station and the case would be heard in the local magistrate or local court. And if you are not satisfied with the verdict of local court, you can approach High Court. The same procedure will follow in High Court. And if you are not happy with the verdict made by High Court officials, you can appeal against it in the Supreme Court. So for ordinary legal right, it takes a lot of time, but for the violation of fundamental rights, you can approach both Supreme Court and High Court. And how can Supreme Court protect the fundamental rights? The Supreme Court it issues various orders. These orders are known as writs. First order is habeas corpus. So habeas corpus is an order which the which a Supreme Court or High Court it delivers so that the accused person or the arrest person it should be presented before the court. So this is this is to make sure that a person who has been arrested, who may be arrested in arbitrary manner, that can be presented before it, and court can look into the manner of grounds of arrest and will see if those grounds are lawful and satisfactory. Second comes mandamus. Yes, this order is issued when Supreme Court or High Court find that a particular office holder was not doing legal duty and infringing on the right of an individual. So if say any police authority, however high may be, from a simple police constable to the Director General of Police, from being a simple village officer to principal secretary, from being a peon to prime minister. If any authority is not working his or her legal duty, or they are infringing on the right of an individual, court can issue that order. Then comes prohibition. It is issued by a high court to a lower court. So if a lower court is going through a case which is beyond its jurisdiction, so these courts, local, high court, and Supreme Court, both local and high court, they have a limitation or a jurisdiction limitation on the areas or the cases which they can hear, which is known as jurisdiction in legal parlance. And everyone has their own sphere under which they can hear cases, the subjects, the limitations which they need to follow. And if a local court it is hearing a case which is beyond its jurisdiction, a higher court, maybe a Supreme Court or a High Court, both can issue an order to prohibit that court from proceeding with that case. Then comes quo warranto. If court finds that a person is holding office but not entitled to hold that office, it can issue this writ and restrict that person from acting as an office holder. So this is not a case of forging, it is also case of caliber and competence. So if a person, if he is illegally or by fabrication, by imposing, by acting as an imposter of a particular office, or by holding any public office from uh, local authority to secretarial authority, if he is not entitled to that post but is still working on that post and restricting the rights of others, in that case court can issue this writ quo warranto and restrict that person from working any longer. And next comes certiorari. Certiorari is the writ in which lower court or any other authority, it needs to transfer transfer to the higher authority or to higher court any case pending before it. So it happens when uh, any authority, whether lower, middle, or higher, they are sitting upon a case, they are sitting upon a matter that need to be delivered. But because of some reason, because of misuse of their power, they are sitting on it. They are not. They're not executing upon the file. They are not working upon the file. So in such a case, a person he can approach the Supreme Court, and the Supreme Court or High Court they can order such authority or such lower court to transfer that matter, to transfer that file to it, so that the case can be heard or the file or service it can be delivered. Yes, apart from judiciary, there are other mechanisms that have been given, such as National Commission on Minorities, National Commission on Women, National Commission on Scheduled Caste, Scheduled Tribe, OBC, all such commissions, including the Human Rights Commission, that have been established by law to protect the fundamental and other rights of all diverse sections of people. Now, let's talk about Human Rights Commission. Yes, real test of any rights given by any constitution is their actual implementation. So the poor, illiterate, and deprived section, they also be able to exercise their rights. So many organizations such as People's Union for Civil Liberties, People's Union for Democratic Rights. They have been working as watchdogs against the violation of such rights. And in this background and because of their protest, the government it established in 2000 a national level institution known as NHRC, National Human Rights Commission. Then this commission it is composed of former Chief Justice of Supreme Court, a former Judge of Supreme Court, a former Chief Justice of High Court, and two other members who has legal knowledge or experience in matters of human rights. So the functions of this commission that it can include inquiry suo moto, that it means it can initiate any inquiry by taking action on its own, by taking initiative on its own, or it can work on petition that is presented to it, or any other complaint or violation. It can also visit to jails to study conditions of inmates or undertake any such research. Now let's talk about DPSP, Directive Principles of State Policy. So at the time of independence, India had many challenges, and the first of these challenges was to bring equality and well-being of citizens. So the government needed to be given such directions so that the welfare of people it can be um, it can be propelled. But since it was it at one hand wasn't the personal discretion of government, but the constitution also did not want to make it enforceable, or did not want to uh, make it a legal force on government authority, because to work for the welfare of people, whether in infrastructure, whether transportation, or for education, for health, or any such policy direction, any such policy decision, they they are subjected to the revenue that is accrued, that revenue that is held by a particular government of any time. Now, if government is not able to provide, not able to cater to all such directives, it may be for many reasons. Maybe the government is not having that much resources. Maybe the money that government has, it is not sufficient. So to be distributed among all the directives, or distributed among all the social policy decisions at a equal pace. So in that case, government would come under a foundation. Government would come under a scanner. So such guidelines that have been incorporated in the constitution, they were not made legally enforceable, because if that was the case, then government or people, they could have acted against the government for not working on a particular guideline. So uh, DPSP being legally non-enforceable means that if a government did not implement a particular guideline, people cannot go to court asking the court to instruct the government to policy. So these are non-justiciable, that yes, they are given to government, but they cannot be called into question, then cannot be enforced by the judiciary. Then comes what are included in the directive principle of state policies. So these directions, they are mainly three. First, the goals and objective that we society should adopt, the vision. Then certain rights that individuals should enjoy apart from fundamental rights, and certain policies that government should adopt. So also direction that includes reasons, some rights, and then some welfare policies. And government has from time to time tried to give effect to some DPSP, because it was, even if it was non-enforceable, it was still a major part of the Indian constitution, DPSP form Part 4 of Indian Constitution, and they are there. So by this, government is it abolished Jamindari, it nationalized bank, it enacted numerous factory laws, fixed minimum wages, ensured the cottage and small industry that were promoted, and has also provided reservation for scheduled castes and scheduled tribe. And it has also enacted many such welfare activities. Now comes fundamental duties. So fundamental duties were included by 42nd Amendment to the Constitution by Indira Gandhi in 1976. At first, these are duties that every Indian should follow, but there has not been anything about enforcing this duty. So as of now, these are not enforceable. So if any person is not following his duties, his fundamental duties, he cannot be called into question. He cannot be called into a force of law. And these duties are simple, that we must abide by the constitution, whatever the law says. Then we need to defend our country. We need to promote harmony among all citizens and protect the environment. So these are some moral duties that had been included as fundamental duties. Then what are the relationship between fundamental rights and directive principles? Both fundamental rights and DPSP, they are complementary to each other. Well, fundamental rights restrain or stops government from encroaching upon rights, while DPSP, they compel the government to work for the welfare of people. So fundamental rights, they mainly protect the rights of individual, whereas directive principles, they ensure well-being of entire society. And it happened that many a time when government intends to implement directive principle DPSPs, it can come into conflict with the fundamental rights, such as to abolish Jamindari law. Yes, now it was protested on the ground that abolition of Jamindari system, it violated their right to property. But since Jamindar at that time, they held a lot of land. So for societal need and for individual interest and for justice and equitable distribution of property, it was necessary that such land, it was to be redistributed among all people, because before the enactment of constitution, people generally did not possess private property, did not possess private lands that belong to rulers or zamindars. And and to give way to equitable distribution, people to lead a meaningful, dignified life. People needed their own personal possessions, which by now were held by big jamindars, some of which held 10,000 or more than 10,000 acres. The rulers, they they held possessions of many villages at a time, around 200 villages under one ruler. So this was a grave injustice, and the element of private property was totally absent by then. So to enforce equitable distribution, government needed to abolish Jamindari system. But since it came into conflict with the right to property, so earlier right to property was Article 31, which formed a part of fundamental right. So now there is a clear conflict between equitable distribution of land to ensure well-being of people so that they can live a life, but it also came in conflict with fundamental right, which say that everyone has a right to property, which is fundamental right, and no government can encroach upon it. So there was a clear dilemma between both fundamental right and DPSP. So government by now it came with an innovative solution. It, it removed the right to property, Art 31, from fundamental right and made it a legal right, Article 300A. So right now, your fundamental right, the right to property, it is a constitutional right, but it is not a fundamental right. So the government amended the constitution to give effect to the DPSP. So this led to a long battle. And there were also a situation after the situation after the abolition of Jamindari itself, the right to property was invoked a lot of time when the government, in order to build infrastructure project, in order to uh, build hospitals, railway lines, road transport, educational institution, it needed land. But since it was a fundamental right, people could not part away with it. So, in order to give effect to such infrastructural project and to set off on a development trajectory, the government abolished Article 31. It removed it from a fundamental right and gave it a constitutional but legal place. The right to property, it has been given here in detail. So there was a fundamental right to acquire, possess and maintain property. Yes. But the constitution made it clear that property could be taken away by government for public welfare. It was made clear by the government. But then they started a long battle. Finally, in 1973, Supreme Court gave a decision that right to property was not part of basic structure. Therefore, Parliament has the power to abridge this right. So by 1978, Constitution removed the right to property from the list of fundamental rights and converted into simple legal constitutional right, that is Article 300. Now, with this conflict between DPSP and fundamental rights, there came another debate that was related to the power of Parliament to amend any part of Constitution. So government said the Parliament has unlimited power to amend any part of Constitution. But the court said the parliament cannot make an amendment that violated fundamental rights or the basic structure. So the legal battle it ended in Keshwanand Bharti case, in which a newer and innovative interpretation of constitution came, in which court said there are certain basic features which cannot be changed by parliament, and such basic structure is what forms a core skeleton of the constitution. Let's talk to conclusion. So in the writing of Jyotiba Phule, we find one of the earliest expression of view that rights include both freedom and equality. So during the national movement, this idea of right was further sharpened and expanded to include constitutional right. And our constitution, this has reflected many such interpretations and many such views and discussions of uh, a whole generation of nationalist leaders. And judiciary has functioned as important protector of right. Judicial interpretations, they have expanded the scope of rights in many respects. We have seen the two examples. The first one is Article 21, and the other one is the right to property, which has been converted from fundamental right to a legal right. Rights enforce limitation on functioning of government and ensure democratic governance of the country. Thank you very much. Kindly subscribe this channel.